child welfare and juvenile justice. First, a couple of housekeeping details. A chat box is located at the bottom right corner of your screen for questions. Questions will be answered at the end of the presentation. This webinar is being recorded and a link will be available on the CIP website later today. Also, if you can make sure that you mute your phone by using *6, that will mute your phone. It is my pleasure to introduce our presenters, Juliet Summers and Sarah Helvey. Juliet Summers is the Policy Coordinator for Child Welfare and Juvenile Justice at Voices for Children. Sarah Helvey is the Child Welfare Director and Staff Attorney at Nebraska Appleseed. Thank you both for taking the time to present this information during the session. And I will turn it over to Sarah and Juliet.
Thanks, Deb. And thank you all for joining us this morning. This is Juliet.
Yeah.
All right. Well, thank you again to the Court Improvement Project. Thank you, Deb, for that introduction, and thank you all for joining us. I am, as she said, I'm Juliet Summers. I am the Policy Coordinator specializing in juvenile justice and child welfare at Voices for Children in Nebraska. And Voices for Children is an independent nonprofit doing child advocacy work at the statewide level. Our mission, vision, and values are that informed research drives our direction. Every year we collect data on child well-being in the state, and we publish the Kids Count report, which you may have seen. It's the most comprehensive data report on children in our state. And we always start from that data, start from research into what works to improve outcomes for kids and families, and that's what we push for on the policy level. And when policies are good, we support it. When a policy is harmful, we fight it. And when it's missing, we can work to create it. And our final part of our central values is that community engagement is how we promote systems change. So we, as a small organization, we can't and don't believe in doing this work by ourselves. It really has to be a coming together of all stakeholders to push for what's best for kids.
Great. Thanks, Juliet. This is Sarah Helvey, and I'm really excited to be here with you all today. A little bit about Nebraska Appleseed. We are a nonprofit, nonpartisan, public interest legal advocacy organization, and we work in the areas of child welfare, healthcare access, immigration, and poverty or public benefits advocacy. And we like to say that we use all the tools in the advocacy toolkit. So we do a lot of work at the legislature doing policy advocacy, which you'll hear about today, and in the community doing community organizing and engagement. And then we also have attorneys and we do legal advocacy as well, including impact litigation. And then we also have what we call the Legal Resource Center, where we provide technical assistance and other resources like amicus assistance to help attorneys create positive precedents in juvenile court cases and to help us identify needs on the ground for systemic change. So if you're an attorney on the call and you're practicing in juvenile court and you'd like to join our listserv, feel free to reach out to me as well or to call us anytime if there's a systemic issue or policy issue that arises in your practice, and we can be of assistance. There's also some resources in an upcoming slide about other listservs that you can join from Appleseed and Voices related to the legislative work that we do. And so with that, we're going to just kind of kick it off and give a little bit of a background about the legislative session.
Sorry.
That's okay. So just a little bit of legislative session 101. Each legislature convenes over a 2-year period, and that's what's called the biennium budget, or the biennium. And you might have heard that term related to the biennium budget, which we'll be talking about as well. But a legislature is a 2-year period called the biennium. And the first year of the biennium is called the long session, and it is 90 legislative days from January through June. So obviously, doing the math there, not every day is a legislative day. There's some recess days built in there. I think for this year, the last legislative day is scheduled for June 2nd. So that kind of gives you a sense. It's early June typically. And then the second year of the biennium is called a short session, and that is 60 legislative days typically from January through April. So we are in the first session of the 105th legislature. Senators can bring as many bills as they choose in each session. I think this year there were about 600, maybe 660, 67 bills that have been introduced, and I think that's pretty typical in that range. All bills must be dropped by the 10th day, and every bill in our Nebraska unicameral will receive a public hearing in a designated committee. And then typically, due to time constraints, only bills with priorities are likely to be heard on the floor. And so as you may have heard, if you logged on early, Juliet and I were just confirming our information. Each senator gets one personal priority. Each committee gets 2 priority bills. And then the Speaker of the Legislature gets to identify 25 bills as a legislative priority. So that becomes really important because those bills are typically the ones that make it through the 3 rounds of debate on the legislative floor.
And before we jump into the substance of some bills that are relevant to the work that you do, we wanted to say this up front, that there are important ways you can get involved in the legislative process. So as Sarah mentioned, every bill gets a public hearing. Some public hearings on bills that we're going to talk about today have actually already occurred, but some are coming up and some haven't been scheduled yet. So if there is a particular bill or set of bills that is really going to influence the work that you do, or you feel like you have important insight on, or a strong opinion about, every member of the public is entitled to come speak at that public hearing, either as a proponent, an opponent, or to provide neutral testimony. So come testify, come tell the senators what you think and get your voice heard on the record. You can also get involved by contacting members of the committee that's hearing a bill. So as the committees don't push out every single bill that they hear onto the floor. There is just limited time. The committee may decide through a vote or as a committee that a bill isn't ready for prime time. And so talking to the individual members of the committee to give your perspective, even if you're not able to come testify at the public hearing, is a way that you can influence whether a particular piece of legislation moves forward or not. Another really important way is to contact your local representative. Our senators are very responsive to their constituents. I'd say Nebraska, because of our sort of simplified system of a one-house, nonpartisan unicameral, divided up into 49 districts, our senators really listen to the people within their district. So find out who your local representative is. If you have questions about how to do that, you can ask us. Both Appleseed and Voices for Children have resources for finding your representative. And then finally, if any of the bills or all the bills we talk about today, you're interested in following or knowing what's happening with them, but this isn't your daily bread and butter, you don't have time to do this yourself, please consider joining one or both of our listservs to stay informed as the bills progress through the legislative process. This is what we do at our organizations. This is our bread and butter, so we track these bills, we follow them, we send out periodic action alerts on bills that we've identified as priorities for children. And if you're on our listserv, that can be an easy cheat sheet sort of way to follow along and see what's happening with a particular bill, where it's going, or what's whether it has stalled out or whether it's moving forward. And we've included the hyperlinks there for both of our listservs. So you should be able to click them right now if you want to sign up. Otherwise, we'll have our contact information available at the end of the session. So I'll give you a short webinar roadmap for where we're going this session. Instead of dividing it up by child welfare, juvenile justice, there are quite a few bills this year that have overlap into sort of both areas of practice in the juvenile courts. So instead, we're going to take a look at the bills in a slightly different way this year. We're going to start with bills that would propose changes to substantive law and policy affecting child welfare or juvenile justice. Then we're going to move on to proposed changes to procedure or rules in juvenile court proceedings. And finally, as Sarah said, we're going to do a brief update on proposed changes to the state budget that would affect funding for child welfare and juvenile justice. So this is where we're going. You also should have access to, if you look at the top right hand of the screen, you can download this PowerPoint, or you could also download a chart that we've created. that has all of these bills laid out, and as well as quite a few other bills that we're not going to have time to dwell on today, telling you which committee they've been assigned to. If they have a hearing date scheduled, we've put that on there for you. And hopefully we'll have a little bit of time at the end you can ask us questions about not just the bills we talk about during the session, but also other bills you see on the chart that you might be interested in. So with that, let's dive in. I'm going to start by telling you the first bill we're going to talk about today, making substantive changes to the law, is LB 8. Senator Chris brought this bill, and what it would do is it would update juvenile probation's administrative sanctions statute. So juvenile probation has been, for several years now, governed by a statute regarding how they can administratively respond to youth acting out on probation. And this statute as it currently exists is just copy-pasted from the adult probation administrative sanctions statute. So what this bill would do is it would update our statutory framework to say that youth who are out of compliance with probation orders probation can respond a little bit more flexibly. Probation is developing a structured matrix of developmentally appropriate sanction options. They wouldn't rise to the level of actually changing the underlying court order, so it couldn't go, say, from outpatient treatment to inpatient treatment. That wouldn't be considered a sanction. It would be things like having to meet with your probation officer more frequently, having an earlier curfew as opposed to a later curfew, et cetera. And the cool thing about the updated statute that appears in this bill is it also offers probation officers latitude to give incentives when youth are doing really well on probation or taking positive steps, because we know the research behind adolescent development suggests that, well, really all children, that the more you can use positive incentives as opposed to negative sanctions, that those are actually more effective for changing youth behavior. And then the final thing this bill does is it clarifies and it sort of hammers home the point that youth can't be detained just on the basis of technical violations of probation. So, being late to curfew is violating your probation order, but if it's not rising to the level of dangerousness that we would otherwise require for detention, so, an immediate risk of harm to self, an immediate risk of harm to others or to others' property, or an immediate risk of flight from the jurisdiction. If one of those statutory requirements aren't met, then detention is not appropriate. Probation needs to respond with sanctioning, or if the behavior goes far enough, with filing a motion to revoke probation and get new orders. And the next bill I'm going to talk to you about is LB 179. This is Senator Bowles' bill, and it is it's a bill coming out of a couple years' work through the Children's Commission. There's a advisory committee on the Bridge to Independence program, which created a task force examining how to extend the program, or the best way to extend foster supports to youth aging out of probation or other young adults who really need the supports and supervision that can be offered by extended foster care. So Senator Bowles brought a bill last year, LB 866, that didn't get out of committee. She brought an interim study over the summer to continue examining the question. And simultaneously, the Children's Commission Advisory Committee on Bridge to Independence continued to look at this question. And this bill this year, 179, is a result of that work. So essentially what it would do is it would expand eligibility to our current Bridge to Independence program as it currently exists, but it would open up that program to youth aging out of juvenile probation with a couple requirements. So in order to be eligible for Bridge to Independence coming out of probation, a young adult would have to be in a court-ordered out-of-home placement on their 19th birthday. So not on run. It has to be court-ordered. They have to be out of the home, and it has to be literally aging out. So jurisdiction is terminating because of the age. They have to have also had a hearing and received a court order prior to their 19th birthday, in the months leading up to the 19th birthday, that court-ordered placement is necessary in order to meet the best interests of the child. And the intent with this language was to try to capture what sort of already happens on the foster care side of things, the child welfare side, where young people are aging out of foster care because they haven't, it wasn't in their best interest to return home. They haven't been able to find permanency. And that was what the group of stakeholders and the Children's Commission Committee is looking at this really identified, is wanting to keep this population narrow to those young people who are aging out of probation, not because they haven't been successful in following their court orders, but because they haven't been able to return home for one reason or the other. They are lacking that family support and the structure of, family support and structure to help assist them transition into adulthood. LB 179, I should note, would not roll out until October of 2018. So it does set the start date out a little bit to give probation and the Department of Health and Human Services time to work together on what this sort of transition planning would look like, as well as figuring out how our federal funding streams could best support this population in being part of the program. LB 556 is Senator Halloran's bill. He is a freshman senator this year, and the bill actually does a couple things, but I'm only going to talk about, it creates a couple different types of offenses. I'm only going to talk about this new offense that it creates, which is a new criminal violation entitled Possession of a Firearm by a Prohibited Juvenile Offender. So what it essentially does is it creates a new felony offense if a young person up to the age of 25 is found to be in possession of a firearm and that young person has been previously adjudicated as a juvenile offender for certain felony offenses. The felony offenses in the bill that can cause you to become a juvenile offender for this statute's purpose they're listed out. They're, high-grade felonies or felonies relating to possession of firearms. But if you want a full list, you can go take a look at the bill. It's LB 556, or if someone has questions about it later, I can go into a little further depth on it. The bill also does provide an exemption for this offense for members of the military. So young adults who would join the military would be exempted. And it also provides an avenue for any others to petition the court to get an exemption. I wanted to list this bill particularly for this audience because I think it involves some questions about how it would interact with sealing of juvenile records. It doesn't really speak at all to sealing of records. I think it also presents an important issue for defense counsel to make sure and know to give notice that pleading to certain offenses, even in juvenile court, would open a young person up to potentially being listed as a prohibited juvenile offender and, and open them up to this charge up to the age of 25 if they were to be found in possession of a firearm. Excuse me. So I think there are still some sort of open questions about this bill that that may need to be hashed out in the legislative process, but wanted to put it on everyone's radar. And I think those are mine, and I'll turn it over to Sarah for a couple more.
Great. Thanks, Juliet. So the first one I'm going to mention here is LB 108. That was introduced by Senator Crawford, and it addresses issues related to children of incarcerated parents. So a few things. It requires police departments, county sheriffs, and state patrol to establish guidelines for law enforcement officers to ensure child safety upon the arrest of a parent or guardian, including things like ensuring that the officer inquires whether an arrestee has children, and developing procedures for the arrangement of temporary care for minor children. The bill would also entitle a parent to make 2 phone calls at no expense at booking for the purpose of arranging child care if the arrested person is identified as a custodial parent or guardian with responsibility for minor children, and specifies that the calls should be offered immediately during the booking process or as soon thereafter as practicable. LB 108 also specifically requires the pre-sentence report to include information about whether and how children could be impacted by sentencing. I know I heard from some attorneys that like good attorneys are already doing that, but not always, and it's helpful, I think, to have in the statute so that can be considered as part of sentencing. And then the bill would require the Department of Corrections to establish policies to support and encourage relationships between parents and the child during incarceration, including things like adopting child-friendly visitation policies, including permitting age-appropriate physical contact for children under age 13, creating an inmate family counsel programs to provide feedback and suggestions to the facility, collaborating with DHHS to support visitation of a parent or guardian by state wards if that's in the child's best interest. And then there is a specific comment that nothing in this section supersedes policies to protect victims from visiting or interacting with an inmate of a child that was the victim of the crime for which the inmate is incarcerated. Okay. And then LB 226 was introduced by Senator Wishart, and she is also a freshman senator this year. And this bill is intended to increase access to driver's licenses for youth in care. And this is something I can just say as Appleseed that we've heard is a big issue for many young people, and has come up through some discussions in the Normalcy Committee of the Nebraska Children's Commission. So specifically, LB 226 would require HHS to provide information and assistance to obtain a driver's license, information to young people as part of the transition planning process, including things like providing the youth with a copy of a driver's manual, identifying driver's ed courses and other resources to help young people access driver's education, helping them identify potential means to access the car for driver's ed, just talking with them kind of about resources available and the basics of obtaining a driver's license as part of transition planning. The bill is also intended to encourage foster parents to help youth in their care access a driver's license. So the bill as introduced also clarifies that a foster parent can give permission for youth in their care to get a license, and this was to address some confusion about whether youth need to get a caseworker signature or like who is sort of authorized. But under existing statute, parental permission is not required for any youth, so we expect there may be some clarification that this is the same for foster youth to reflect sort of the intent of that. The bill would also provide liability protections for caregivers, so similar to the liability protection in federal law and in last year's LB 746 for caregivers making reasonable and prudent parent-centered decisions. LB 226 also clarifies that caregivers, so meaning foster parents, are not, or a designated official at a child care institution, are not liable for harm caused to or by a child who obtains a learner's permit or a driver's license if the caregiver is acting within a reasonable and prudent parent standard. LB 226 would also permit wards age 16 or older to contract for the cash purchase of a car and an individual car insurance policy with the consent of the court. And then it also directs the Normalcy Task Force under the Nebraska Children's Commission to examine costs and benefits of implementing a program to help foster youth better access insurance, like type of insurance pool or other resources in the community, kind of look at what other states have done around that. And then LB 296 was introduced by Senator Baker, and that's to apply the provisions of the Nebraska Strengthening Families Act. Again, that was in last session's LB 746 to youth and juvenile justice placements. This has been a key recommendation of the Normalcy Task Force and a group of stakeholders that has been meeting for the past couple of years. It also requires what the bill calls child care institutions and juvenile facilities. Those terms basically cover the range of group or congregate care settings, including YRTCs, to develop a normalcy plan, outlining things how they will implement normalcy in that setting, such as efforts to provide and address barriers to normalcy, policies on staffing and supervision and permission to participate in age-appropriate activities, given that setting, a list of activities that the facility provides on site and in the community that the facility can support. And this was the result of, I would say, input of providers and stakeholders who, as part of the Normalcy Task Force, who said this should not be top-down, but an opportunity for those providers to say how they can implement normalcy in that context. The bill also requires, this came out of the Trafficking Subcommittee, the Normalcy Task Force, HHS to develop regulations on training for foster parents on human trafficking. And then there are 2 provisions in the bill that would permit the dissemination of a photo of a state ward missing from care consistent with confidentiality statutes. So the main thrust, I think, if you look at the bill, is the applicability of normalcy to juvenile justice, but it includes some additional recommendations that came out of the Strengthening Families Act or Normalcy Task Force. Okay, and then LB 411 was introduced by Senator Bowles, and it makes some clarifications to the existing sibling placement and visitation statute. It clarifies that the reasonable efforts requirement for sibling placement, visitation, or ongoing interaction applies even if the children have no pre-existing relationship. This is an issue, has been an issue, I think, in a number of circumstances, but namely with an infant sibling who essentially did not have a pre-existing relationship, but also in adoption, other situations. So I think this bill would further clarify, and make sure there's no confusion as to that point. LB 411 would also require HHS to send copies of notice of placement change to known siblings and to file a sibling placement report every 6 months, or essentially at the 43-285 intervals. The report would include the reasonable efforts HHS is taking to locate the child's siblings, and then if a joint sibling placement is made, whether that placement continues to be consistent with the safety and well-being of the children. If joint sibling placement is not possible, the report is to include the reasons why such placement is and continues to be contrary to the safety or well-being of any of the siblings, and HHS's continuing reasonable efforts to place with the sibling and to facilitate visitation. LB 411 would also grant the right to intervene to a sibling for the limited purpose of seeking placement, visitation, or other ongoing interaction, and specifically would permit any party who has intervened and whose substantial rights have been affected by a final order to appeal such order. And so again, just some clarifications there. And then finally, and I think importantly, the bill has a provision to be clear that this is not to be construed to subordinate the rights of foster or adoptive parents to the rights of the parents of the sibling, or the rights of an adoptive foster or bio parent to the rights of a child seeking placement or visitation.
Sarah, you had a question on that one down in the chat.
Oh, I did. We had a question that is, how do you foresee a child sibling intervening? Would they get a court-appointed lawyer? And so I do not read the bill to require a court-appointed lawyer, so I think that, from an advocate's perspective, that is a limitation. So I think it would have to be, when I've seen this in the past, it has been, a sibling intervening by and through an adult, like an adoptive parent, or it could be an adult sibling. So they would have to have the resources to hire an attorney, which would be a limitation. Hopefully that answers it. The question is, what about siblings who have been adopted out prior to the birth of the new sibling? So I think this would apply to siblings in that situation, to clarify that. Okay, thank you.
Any other questions on that? And we'll move on to bills that would make changes to more procedural aspects or rules of the court or rules of administrative bodies. So I guess, sorry, the first ones are going to be Sarah's. Here you go.
That's okay. Thank you. Yeah. So the first procedural bill is LB 10, which was introduced by Senator Chris. And this bill would add a juvenile judge in Omaha in counties having 400,000 inhabitants or more, so that's Douglas. And as probably a lot of people on this call know, this has been introduced multiple times in previous years without passing, but the bill had an early hearing and has already been advanced out of the Judiciary Committee. As introduced, the bill would increase the number of juvenile judges in Douglas to 6 from 5, but there is a current committee amendment pending that would increase that number to 7. So this appears to be moving a little bit already, and it's something to watch. I know it's something that's very much needed in Douglas County. The next bill is LB 180. And this bill creates a procedure for what's called a bridge order in the bill in a situation where a non-custodial parent has been determined fit to safely care for a child. So the bill permits, upon the motion of a legal parent or on the juvenile court's own motion, or under an amendment that was introduced at the hearing, a guardian ad litem, permits on a motion a bridge order transferring jurisdiction over a juvenile's custody, physical care, and visitation to the district court and terminating juvenile court's jurisdiction under 3A. So upon motion, the juvenile court under the bill is required to set it for an evidentiary hearing within 30 to 90 days. And then also under that amendment, there would not need to be an evidentiary hearing. It's specific if all parties stipulate. Such an order is permitted under the bill if all of the following criteria are met. There is an active juvenile case that has been adjudicated 3A and its post-disposition. So in the language of the bill, a dispositional order is in place. Paternity has been established. The juvenile has been safely placed by the juvenile court with a legal parent, and the juvenile court has determined that its jurisdiction should properly end once orders are entered in the district court. And the order shall address only matters of the legal and physical custody and parenting time. Following the issuance of a bridge order, a party can file a modification petition in district court. If the modification petition is filed within 1 year of the bridge order, the party requesting modification is only required to show that a modification is in the best interest of the child rather than demonstrate a substantial change in circumstance. And then also, if filed within a year, filing fees and court costs are not assessed against the parties. And this bill, as I referenced, had a hearing last Thursday in front of the Judiciary Committee. And then finally, am I still on the slides? Yes, LB 188 was introduced by Senator Howard. And this exempts a bio parent convicted of sexual assault from the definition of family for purposes of requiring reasonable efforts. It also requires, that a child also states that a child conceived by the victim of a sexual assault, it also states that if a child is conceived by the victim of a sexual assault, a TPR petition shall be granted if such termination is in the child's best interest and the perpetrator has been convicted, pled guilty, or no contest to sexual assault, or the perpetrator has been found beyond a reasonable doubt to have fathered the child as a result of sexual assault. The bill would also require that the court stay a paternity action if there is a pending criminal allegation of sexual assault under 28.320 against the alleged father with regard to the conception of the child. If the alleged father is not found guilty, the paternity action shall proceed. If the father is found guilty, the paternity of the child is established by the conviction, and the parental rights of the biological father may be terminated.
Jill Holtz asks, is there any language in this bill about ICWA and active efforts? I think the short answer is no.
Yeah, and I assume if she's asking about the bridge bill.
Well, or the TPR bill.
Yeah, I'm not sure.
Yeah, because I don't think there is either.
Yeah, TPR. Yeah, TPR. No, there's not. That's a thank you for raising that. Because I would say that, ICWA would have to be read with that. She's typing. Yes.
Yes.
Yes. The different standards apply in that case, and there, it might be helpful to clarify that. Okay, and then, thank you. And then LB 397 was introduced by Senator Justin Wayne, also a freshman senator this year. I think this one probably is of interest to this crowd as well. This bill would require the application of the Nebraska evidence rules at TBR proceedings and prohibits consideration of evidence which is inadmissible in criminal proceedings. The bill is really, as written, as simple as that, so I'll just leave it at that. I know there's potential for a lot of discussion around that, but it really is a pretty straightforward bill. And then also introduced by Senator Wayne is LB 658, and that establishes the right of a parent, guardian, or custodian during any adjudication or dispositional proceeding under the Juvenile Code to have appointed one expert witness whose reasonable fees and expenses shall be paid by the county if the parent is indigent. The bill would also require the report of any evaluation of the juvenile ordered as part of an adjudication or disposition proceeding to be made available to all parties at least 15 days prior to the hearing. With that, I think I'm handing it back over to Juliet.
Yeah, so a couple more procedural or rules issues. LB 11 was from Senator Christ. This is responding to a couple Supreme Court holdings that came out this fall regarding motions to transfer between juvenile and criminal county or district court. So a couple years ago, the legislature in LB 464 changed our statutory scheme for where juvenile cases can be filed, starting most cases in the juvenile court, and then allowing county attorney's discretion to file in either juvenile court or district or county court in the cases of the most serious felonies for older juvenile offenders or juvenile suspects, and then permitting county attorneys to file a motion to transfer a case from juvenile court to county or district court, and setting out certain things that the juvenile court would need to consider in such a motion hearing. So the holding from the Supreme Court this fall was that such a motion to transfer or an order transferring a case from juvenile to criminal court did not affect a substantial right and thus is not a final order for the purposes of appeal, that when a child or a juvenile has their case transferred from juvenile to, say, district court, they have to go through the entire trial and sentencing process before they can go back and appeal that order transferring the case to, criminal proceedings. So what this bill does is it responds to that and says, no, the legislative intent is that a transfer from juvenile to criminal court, or for that matter, a decision by a county or district court retaining a case in county or district court, not transferring it to juvenile court, does affect a substantial right, creates a statutory right to immediately appeal that order as a final order. I would say here that we at Voices for Children strongly support this bill as a means to make sure that the question is decided in a timely way before the ability to access juvenile court is completely lost. So the timing of criminal trial, criminal sentencing, and then the appellate process is such that a young person whose case is transferred erroneously might lose any meaningful right to have that considered because they might turn 19 before the trial, sentencing, and appellate process would be finished. So all this bill does is just move up the timing of when that appeal would be permitted to happen. LB 158 is Senator Pansing Brooks's bill. This is an extension of a bill from last year, LB 894, which it's actually essentially the same bill that she brought initially last year, but on the floor last year, LB 894 got amended to apply only to the 3 largest counties, most populous counties in Nebraska. So in current law is that in the 3 most populous counties in Nebraska, all children charged in the juvenile court are given immediate automatic appointment of legal counsel at the time the petition is filed. And then there are certain provisions related to waiver of counsel that apply statewide. So that's the status of the current law regarding legal counsel in juvenile proceedings. And the Senator has brought this bill back to extend the automatic early appointment of legal counsel statewide. And I think the bill, this year attempts to respond to some concerns about costs a little bit more than it did last year by retaining provisions relating to parents' ability to pay if they're, there's a family that can afford legal counsel. The judge can inquire into a family's ability to pay rather than retaining an appointed attorney at the county's expense. But otherwise, it's trying again to get every child charged in juvenile court access to a lawyer. And then LB 434 is Senator Ebke's bill. Senator Ebke is the chair of the Judiciary Committee this year, and this bill will be heard in front of the Judiciary Committee. And it would eliminate a requirement for the use of teleconferencing or video conferencing in evidentiary hearings. Currently, the law requires stipulation of all parties in evidentiary hearings. It would strike that requirement of stipulation so long as the use of the video conferencing or teleconferencing ensures preservation of, quote, due process rights of all parties. And moving on, if we don't have any questions about any of those, we will touch very, very briefly on the budget so that we can leave some time for any questions about anything we've talked about so far or about anything you see on the chart.
Great. So I'm going to mention a few bills that are budget related, and then Juliet will come back and talk more broadly about the budget. So the first bill to mention is LB 189. That was introduced by Senator Howard. And this is an appropriations bill that would appropriate $1 million over the biennium for the purpose of providing HHS with specific resources to meet caseload standards, which were specifically set out in statute in 2012 and I think range from 12 to 17 cases. This is in part in response to the Office of Inspector General's report, which for the past 4 years has found Nebraska out of compliance with those statutory caseload standards. And also, there was an interim study on this issue and discussion of this. The Office of Inspector General's report also included an investigation of 22 cases in the last year that resulted in the death or serious injury of children in care, and high caseloads were cited as a factor leading to the outcomes in many of those cases. So this is an issue that's I think rightfully getting a lot of attention, is a really critical issue right now. So I would say this bill is one to watch, and I know that it's something that is, felt profoundly by the families and professionals working in the system. But it also is a pretty simple bill, just a straight appropriation that has been referred to the Appropriations Committee. Second, LB 334 was introduced by Senator Reapy at the request of the governor. And this bill would cut short a pilot project aimed at evaluating the effectiveness of the family finding model in Nebraska. That family finding pilot was established in a bill passed in 2015, LB 243, that was introduced by Senator Bowles, which included a specific appropriation and required HHS to contract with private providers for family finding services in a few different service areas. Under LB 334, DHHS may continue to perform family finding activities in-house within HHS caseworkers. And then finally, LB 336 was also introduced by Senator Reapy at the request of the governor. This bill would permit HHS to charge a reasonable fee in an amount set out in HHS regs to cover expenses in carrying out central registry checks. It would the bill specifies that the fee is not to exceed $300 and that the fee may be waived if the requesting party shows undue financial hardship as a result of that fee.
And Jill asked if the OIG investigation included caseloads of the tribes as well. I think the OIG is only has jurisdiction to investigate where a state agency is involved. So the Department of Health and Human Services, if there's a case, where there's a Native family involved with the HHS, that would have been part of the investigation. But if it's complete tribal jurisdiction, I would think not. Someone can correct me if I'm wrong.
And then Neely Boyer from HHS is saying that $336 is not to exceed $3 instead of $300. So while Juliet's talking, I'll just confirm that. Thanks for that clarification. Look at the bill and let you know for sure.
Okay.
All right.
I think we've got a lot of questions on the budget. I'll run through these other ones, and then we'll skip back and answer some of the questions about the chat. So the other state budget proposals, the governor's proposed budget is largely encapsulated in LB 336, but it can be a little hard to read to know exactly what is changing or not changing. So a good place to look to see kind of, what the priorities are and whether these budgets are going up or going down is if you look at the governor's state budget proposal, which you can find on the state treasurer's webpage. And the way this process works is the governor proposes a budget. The legislature has to pass a balanced budget, constitutionally obligated to pass a balanced budget by the end of the session. And so what the resulting budget, is usually a combination of the governor's proposals and then, ideas that come from the legislature. All the agencies have to have separate appropriations hearings before the Appropriations Committee to comment on the proposed budget modifications and their agency requests. And so, if you have input on any of these, budget proposals or these, these ideas for funding, the appropriate place to comment is the public hearing for the agency before the Appropriations Committee, which usually happens in February or March. So these are just current proposed budget modifications. They're not, obviously set in stone yet. So a 4% reduction in general funds to the Supreme Court, which includes, obviously, juvenile probation. To the Crime Commission, a reasonably small reduction in community-based juvenile services aid of $180,000. It would eliminate the ongoing state investment in the Rural Practice Loan Repayment Assistance funding. I confess I don't know enough about how this fund works. It may well be that there is enough money already in the fund that payments to support lawyers going to practice in rural areas, could continue through the fund, but it does look like ongoing state investment would be cut. And then it does increase funding to improve staffing ratios at YRTC, particularly YRTC Carmi. So that's on the juvenile justice side. On the child welfare side, there's a proposed reduction of general fund appropriation for various provider contracts by 2.2%. A recommended 50% cut to contracted foster and kinship placement services, and then recommending moving those support services like ongoing training support, et cetera, in-house with the HHS caseworkers, and then eliminating contracted post-adoptive and guardianship supports, so like right turn, for example. So those are, obviously we're in a very difficult budget year. And our legislators and our governor are looking at places they can make cuts everywhere. Child welfare and juvenile justice are not accepted. I'll tell you that from the perspective of my organization, we really see funding for both child welfare and juvenile justice as investments against future, more costly spending, whether that's in lengthier stays in foster care and lengthier timeliness to permanency, or whether that's eventually paying, for more prison space in our correctional system. So we are absolutely intending to support the good work of our caseworkers and our probation officers and our contracted providers to make sure that we're investing at the front end in ways that we can, prevent these longer-term worse outcomes. That, I think, is all we have for you guys. So we would be welcome to answer any questions if there are some we haven't answered yet on this chat, or if other people have issues or bills that they want to bring up.
I just want to say, make sure everyone heard it, that that Neely was correct. So I stand corrected. The fee is not on the central registry check is not to exceed $3. I said $300. So that might be my most famous error in a presentation to date. So thank you, Neely, for that clarification. And again, even with that fee may be waived if a requesting party shows undue financial hardship. So I apologize for that. I also want to note there was a question if the family finding is to be done in-house, who's expected to do the family finding, given what I shared about the case loads. And that is not clear in the bill, and I haven't heard how that is proposed to be handled.
Jill, I'll tell you that looking at the governor's budget proposal, one of these cuts, there was funding to in order to bring it in-house. I want to say it was the foster and relative placement supports to create 14 new positions in order to do some of this work in-house. But I will say that from our perspective, we remain really concerned, given that caseloads are already very high. And obviously, from the Inspector General's report, have contributed to some really serious outcomes. That we want to make sure that our department, our agency, if this kind of work is going to go in-house, is appropriately funded to make sure we have the right people doing that work and are able to stay on top of all these important programs.
Thanks for that.
And then there was a question about Medicaid. Sarah, did you want to?
I haven't. I'm trying to scroll.
Yeah, I'm having some trouble scrolling too.
Yeah.
So Katie asks, many youth in child welfare and juvenile justice receive services through Medicaid. Do you have information regarding those reductions?
I don't specifically. I'm sorry. I know that there have been some, but I'm just not prepared to speak to that in detail. I'm sorry. I can certainly follow up because that's something that Appleseed's working on, but I don't have all the information for you today, so I can follow up.
And then Cassie Blakely says, during the hearing on 334, the department shared that family finding done in-house would not be done to the full model. That is the ongoing way of doing business. And yes, I think that is something we've heard as well for some of these. So family finding is one example. The alternative response demonstration project is another example. And I think that, yeah, so that's certainly what we have been hearing. I just want to, make sure that if we're asking our caseworkers to take on more and more and more responsibilities, that that we have enough caseworkers and that we're funding them well enough to do all of these different, types of activities that support kids and families. With LB 108, does it address a person who may be incarcerated or arrested that has guardianship or the responsibility of caring for an adult with a disability? That's a great question, Mindy. It does not. It is only related to dependent children. But that's a great point. Any other questions?
it looks like that is it for our questions. So I want to take this opportunity to thank both Juliet and Sarah for their information. I know that you have spurred lots of good discussions, and as a reminder, we will be doing a follow-up webinar to this webinar after the legislative session is over, so then we can kind of move forward with our work from there. Again, as another reminder, this webinar has been recorded and will be available on our website, so if there is information that you weren't able to glean the first time, you can catch it at another time. So thank you again, and we appreciate your attendance. Have a great day.